Good morning. I am Leslie Hocker. I'm with the Michigan Notary Association. I'm the president and co-founder. And today I want to talk to you about estate plans. We already have a video up about how to get attorneys to talk to you about estate plans. If you aren't a salesperson, if you don't like to present new ideas to people who have very much dug in their heels in the way they do things, this might not be for you. However, you could be contacted by a third party and just ask you to notarize an estate plan, and you might want to know what you're doing, and that's what this video is for. So I have been closing estate plans for over 3 years for one particular attorney, but for several others, multiple times. I probably have closed, I think the last time I counted, I was over 3,000 estate plans. So I want to let you know, first of all, don't read the documents. Okay, so this is how it works coming from the estate planning side. So, you know, when you're closing a loan and you have people who are buying their most invested purchase, they're spending hundreds of thousands of dollars, and you're there to get their signatures, and the loan officer is supposed to do their job, and they're supposed to explain all the documents, and you're there and you are told by the loan signing companies to give a sentence or two to explain what the document is. That doesn't apply with estate plans. With estate plans, the lawyer has already gone through everything. So these estate plans, know that they cost the client between $2,500 and $7,000 or more. Some have told me there are estate plans that include their businesses and other entities, multiple homes. They've paid over $10,000 for an estate plan. So this is not a cheap thing. This isn't one of those things that you want to go, okay, it's okay. You know, it isn't only a anything. It's pretty serious business. It's also not your business. So as notaries, our job is to gather signatures, okay? We have to properly identify the signer. We have to make sure that the signer is aware of what they're signing and that they're signing of their own free will, okay? That's the important things that we're doing. The other things we're doing, sometimes we're printing these documents and sometimes we're not. I hear people say, but I want to go through the documents, make sure I don't miss any signatures. I guarantee you're not going to miss any signatures. The trust. So let's talk about the trust. We're going to talk about each of the documents, and I've got it here. So you want to show up looking professional, not like what I'm dressed today, because this is not something I would ever wear to an appointment, but it is something I'm going to wear to a Zoom when I don't have any appointments until 12:30 today, and it's 9 a.m. So the first thing you have is the trust. Now, some attorneys use a binder like this. Some will use the 3-ring binder. Some will just send you the documents and you're going to end up putting them in a manila envelope and sending it back to them. However it is you get them back to the client, to the attorney, please make sure it's not in a rubber band, because a rubber band is going to rip the papers. I don't care who tells you what, a rubber band will rip the papers. This is a presentation that means a lot to the people who are getting their estate plan done. This is legacy paperwork. This isn't stuff that's getting shoved in a drawer and never looked at again until they sell their house. This is paperwork they are keeping. This is paperwork that will be pulled out in the future every year to re-sign their healthcare and financial power of attorney. This will be pulled out when they get sick, when the kids need to take over, when they need to change their will, or when they need to use their will. All of these things are being pulled out again. So please make sure you send the paperwork back in a fashion that still will be able to be used for years, okay? So a trust is pretty thick. Look at that. It's anywhere between 65 and 80 pages. None of these pages are your business. Not one thing. When people put together a trust, they have to answer questions that nobody wants to answer. They have to answer questions like, who's going to take care of your children if you die? What if you die together? What if you die along with the person that you say is going to take care of your children? These are questions that hurt their heart to think about. Okay. These are questions that the answers to them are not your business. They're not my business. They're not the business of their children. It's not the business of their parents. It's not the business of anyone but the two people or one person who's putting together a trust. So keep your nose out of it. I understand there are people who say, but I can't settle in my mind notarizing a document that I haven't read. You're not notarizing a document. You're notarizing a signature. That is what we do. We notarize signatures. That signature can be written on my arm, and I can notarize that. It is a signature. It does not matter what it's attached to. It matters that the person who signed it is who they say they are. It matters that the person who signed it is aware of what they're signing, and it matters that they're signing of their own free will, as in not being coerced. Okay, that's it. All of these pages don't matter. Here's where it matters. Right there, last page. That's what matters. Okay, so for a trust, you're going to turn to the back. Now, fun thing about the trust, I don't know where the other page is on here. I probably put it opposite. There it is. The second to last page, that's the signature page. So you can flip to your heart's content, but I can tell you there's one signature page in a trust, and that's at the very end. It's the second to last with this attorney. Most attorneys, if you don't do a lot of work for them, they're going to print the documents and flag everything for you. So if you start going through them, they're going to be really mad at you and never use you again. We had a notary who read the documents, proceeded to have a conversation with the client about something they wouldn't have known had they not read the contents of the documents. And then the client told the attorney about it. And now that notary will never be used by this law firm again. Just keep your nose where it belongs. Okay, so when you're presenting, so we're going in, the first thing I do, obviously greetings. Okay, hi, how are you? Beautiful home. Listen, there is something good about everybody's home, whether it's the smile on their face, their warm welcome, their kindness. Something is good. You have a beautiful home. Oh my gosh, what a beautiful smile. Like, find something to compliment them because they're on edge, and you complimenting them brings them back down and makes them feel loved. Okay, that's what they need because they just reviewed some really tough documents. Okay, so when you get there, you're going to first set out your things. So I have my bag right here. I have my journal. Oops, upside down. I have a cool little Mina. Now you wonder what this is for, right? You're like, what is it for? I'm going to show you in a second. It's a mouse pad, and it will be available if it's not already. It depends on when you're viewing this. It is in the Mina store, but here's what it does. Let me see if I can move my camera so you can see it. Excuse the bar. It's my husband's voice. But see, now I'm not hurting anybody's table. I keep my things on here, so I'm not hurting anyone's table. Okay. All right. So I get my embosser and my stamp out because on estate planning documents, every document gets stamped, and you can't use an embosser unless you stamp. All of them get embossed. So both on every single document that you notarize, on every single notarization, you use both. Okay. They also want you to fill in that thing on your stamp, the acting in the county of, even if you're in your home county, they want it filled in. Leave no blanks. These are legacy documents. I closed a loan the other day, and actually it was a sale of a property, and the people couldn't understand why the first notary went to the wrong address. And it was because the address in the trust was the address they had 8 years ago when they put the trust together. They need to update their trust. Anyway, that's how personal it is. And that's how much these things get put away and not brought back out. They didn't even think about it. So think about all the things without saying all the things. Being a notary means you have a whole lot of knowledge that you can't share. Okay. So this is kind of a behind the scenes thing of what it is. All right. You're not an attorney, can't give legal advice. Okay. So journal. I keep my journal. Let me see where it can go here. And I fill one of these out for each client. Michigan doesn't require a journal at this point, but for my peace of mind, I have it. So I fill all these out, and when you take our Notary Basic Education, this is shown on the screen and shows you how to fill it out. So if you haven't taken the class, please do. And if you have taken the class and you forgot this, you can come back to any class anytime. Okay, all right. So I fill out my journal. I fill out my journal. I am the one who has to be able to read it, and I need to make sure the information there is correct. So that means I fill it out, not the client, because what is one way to be fraudulent is to let the client fill it out and they can put whatever information they want there. Yeah, you're going to double check it, but no. So I fill it out, they sign it. And I'm not going to show you where they sign it. I mean, I'm not going to show you any signatures, but I always have them sign right, let's see. 1, 2, third line up right there. Okay. And it actually says in there signature. So they're signing that, not you. The client signs that. Okay. And then what do we put over here? Because by law, if you keep a journal, you have to put what time it is. And then you have to put how much you charged. So I put the time that I'm there over here where it says fingerprint or other information. And then under here where it says how much we charge, it says notary fee. I put package because it is a package. It's 10 per. I always take pens from the law firm if they provide them, and I leave those with the client. But this guarantees that we use the right color pen. For these documents, every single attorney I've spoken to wants us to use blue ink. Okay, so they provide me pens. So the first thing I do is I pull out the estate plan, and like I said, the signature page is the second to last page. I pull it out. I say, this is your trust. When I walk in the door and I'm issuing pleasantries, one of the things I ask is, did you have your review? I already know the answer. I know they had their review, but it's part of making sure they're of sound mind. Okay. If they say no, we're going to have more questions because maybe their short-term memory is really bad, but maybe their a little bit longer-term memory is really good. And as long as they know what they're signing, that's all that matters. Did you have your review? Yes. Beautiful. Did everything go well? As I'm getting papers out, they say, yeah, great. Is there anything that needs to be changed? No. Okay. No problem. So I give them the paper. One signs, the other signs, and or if there's only one person, obviously only one signs, then I bring it back, I sign it, I stamp it, I fill in my stamp, and I emboss it. All done. Okay. It is, yes, that fast. The longest time I think it takes is when we have a signer who signs really slow. But that's okay because I schedule an hour for each appointment because I think it's important to be able to give people the opportunity to read if they want to. So next we have your certificate of trust. I need your signatures right here. And they sign, and I sign, I stamp, I emboss, I fill in my stamp. We move on. Okay. Again, it takes them longer. Next, we have our financial power of attorney. Now, in this packet that I have, there are 2 signers. So we have it divided. Okay. The financial power of attorney, again, they're signing at the end. So there are pages where people accept agency. Now, if you read the law that came into effect July 1st of this year, 2024, July 1st, 2024, there is a law that came into effect. Let me see if I can find the new power of attorney law. It is called 556.201. It's part of the Uniform Power of Attorney Act in Michigan. Okay, so I urge you to read that because it lets you know and it can settle in your mind, can I be a witness and a notary on the same document? That actually says yes. If the powers of attorney were written correctly, then yes, you can. Now, what does that mean? So I tell you, you don't read the documents, but you do have to read the notarial block. Every single notary block, you need to read that because that's your part. That part is for you to know how to proceed. Do I have to issue an oath? Is this an acknowledgement? Am I notarizing one signature or 2? When I if I have to put the names in that notarial block, I have to write those names exactly how that is written on the signature line for the client. So if it's first name, middle initial, last name, that's how I have to write that in the notarial block. good lawyers write that for us, but this is for everything. It doesn't matter. Some of this information is just general notary information, okay? So when we read the notarial block, we see who we are notarizing for. If it just says the client, that's great. If it says client and witnesses, that means no, you cannot act as a witness and a notary on that document, okay? So reading that notarial block is super important. And then after that notarial block on powers of attorney, there's a page to accept agency, okay? So I'm trying to flip it up really quick. No one can act on behalf of another person without them accepting agency. So fun fact, as of the time, the date of this 10/16/24 is when I'm doing this, putting this video together for you. The powers of attorney that are on the michigan.gov website are incorrect. Okay, just so you know. In the notarial block of the, I don't remember which one of them, it doesn't give the date properly. It says on this day of 2024. It doesn't say what month. On this blank day of 2024. Like I'm not counting days, so I have to write in whatever month it is. So I'll put 24 October 2024, okay? Just so you know, you have to read that notarial block. If I didn't read that, I wouldn't know. If I just assumed it was correct because the state put it together, not cool. So on the financial power of attorney, it's one signature at the end. That's it. So on this one is separate. So when you know, the first two documents the people signed, they're both signing the same thing. So there's a little bit of a, what do I do here when it gets to the powers of attorney? Because the first one, he signed, she signed, it came back to me. The second one, he signed, she signed, it came back to me. The third one, you want to say, okay, now we're on to our separate documents, okay? Because what's going to happen is he's going to sign it and pass it to her. So what I do is I always put hers first because it's always him signs, she signs. So if I say here, this is your financial power of attorney, they know it's not, he knows it's not his, okay? But he does usually have to sign to accept agency. And if he doesn't, then what you do is when you get to that page, you say, is, you know, Charles here or whoever it is, so that they can sign to accept agency. Now, what if they're not here? It's okay. That part's not notarized. So it doesn't need to, you don't need to be there. So what happens is when I get done with all this paperwork, I send it back to the law firm and they record it. So they're keeping a digital copy and then they send everything right back to the client. So just tell them when you get it back from the law firm, you can go ahead and pull out the financial and healthcare power of attorney, and then they can sign to accept agency then. Okay, they've already been told this, but this is the reminder. And then if it's in a binder like this, I show them where it's at in here, like which tab, okay? All right, healthcare power of attorney is a little bit different, okay? This one you do need to flip pages. It is literally the only document you flip pages, okay? The only multi-page document. Okay, on the healthcare power of attorney, what I say is, do you remember during your review on the healthcare power of attorney, option 1, option 2? And they will say yes or no. And if they say yes, I say, do you want to make that decision today? And they say yes or no. And if they do, they do it. And if they don't, they don't. It does not need to be notarized. So it does not need to be initialed in your presence. So the option 1, option 2, they can initial in their presence. Now, some attorneys have these all written out. This attorney just happens to have it in columns, which I think is great. So if it's all written out, they can make those decisions. They've already talked, in my experience, okay. In my experience, the attorneys who write them all out separately and have them initial separately have already had the conversation and they've already decided yes on those topics. Those are the only ones included, okay? The other ones, the healthcare power of attorney that you're getting from the website or from like LegalZoom or wherever, which you're not getting, you can't provide paperwork for anybody. But the healthcare power of attorney that comes from online, they will have to read each one and initial the ones they want. Like if they go back later and add an initial, not my problem. I'm there for the signatures. Okay. All right. So we move on to the next page. They do have to certify that. So they have to sign there and it's just certifying that I've read the provisions. No one ever questions it. They don't ever ask. They know they have to sign because they've already had their review with the attorney. And then toward the end, in front of the acceptance by agents, that's where they're signing. That's where the witnesses sign, and that's where it gets notarized. Same thing. Now this attorney in particular, he does something that I really love. When things become routine, we forget. We tend to do things mindlessly. So on this attorney, on the financial power of attorney, the witnesses have to print their name, sign their name, print their name. So they're printing their name in the notarial block, and then they're signing their name, and then they're printing their name underneath that. But on the healthcare power of attorney, it's only signing and printing. They're not writing it in the notarial block. And then when we go to the next document, it's the wills, and they have to print, sign, print again. And that keeps everybody on their toes. Okay, it doesn't keep me on my toes because I've done so many, but it's very, very ingrained in me. So I see if something is different. And I do have some witnesses that I use repeatedly, and they know if it's right or wrong, and it's very adorable. Okay, their will. Again, none of your business. Do not flip pages. This is your will. Last page is what's signed. Period. Don't read it. Not your business. That's what got the other notary in trouble. Okay, so there's a lot of pages. It is, it becomes not curious once you've done a few of them. You just go, okay, this is what I do. And if you can stay on track and remember that, it's great. The next thing they have is personal assets. So when they transfer their property, their personal tangible assets into the trust, they have to give it to the trust, and then they have to accept it into the trust. So they are the grantor and the grantee. Like, here, I'm giving it to you. Oh, thanks, I'll take it. And it's the same person giving it to themselves. So it's kind of like taking a selfie, I guess. Anyway, so they both have to sign both pages, and then the second page gets notarized. Okay. And then we have deeds. So when they do a deed, okay, so let's talk about, there's a property transfer affidavit. If you've done a loan, you know this. Sometimes there is a homestead exemption, the PTA, no, whatever it is. It's not in this package because not all counties require it when you're putting it into a trust. They already know what they're doing, so don't ask if it's missing. Okay. Quit claim deeds. They're quit claiming it from their personal ownership to the trust owning in it. But you don't have to explain that. You just say, this is your deed to put your house into trust, and they go, done. Now, sometimes the deed has a second page, and that they both need to be printed on legal. I say on legal paper. If they send it to you on legal paper, print it on legal. It is, it's actually in the laws that you cannot shrink to fit it. Okay, so you can't take something that's on legal and shrink to fit it onto standard letter size paper. It's against the law. No shrink to fit. It's actually in the law. Who knew? What's also in the law is that the top of, where are we at here? The top of it needs to be 2.5 inches from the top of the words that say quitclaim deed. I have this light thing going on because it's really dark down here. Okay, so the top of the quitclaim deed, this margin has to be 2.5 inches, and it can't be less than that, or it'll get rejected. Now, is somebody measuring? I'm sure by now, everybody who's recording these knows exactly what it looks like. But then how do you make it fit when everything else in the whole document, the whole package is letter size, and this is legal, is too big. So what you do is you put the property transfer affidavit, line it up at the bottom, just like that, and then fold it over. Okay, fold it over like that, and then it's the same size. Fold it from the top. And so okay, so all the way through this package, they sign their name however they want to sign their name. However they normally do, they can sign it. Okay, it should match their driver's license. It should be fairly close to their driver's license. When they're signing anything to do with property, it has to be signed exactly the way their name is written on here. Now, with these people, it's not a big deal. They were signing their name that way anyway. So this one has both their names, first name, middle initial, last name, and they signed that all the way through. No big deal. But there are some people who don't normally sign their middle initial. If it's there, they have to put it. If it's not there and they normally put it, that's fine. I know this feels so flip-floppy, but it's really not. If you can't read their signature, if it's just like a dit, 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 I wish I could show you the one in my book. It's literally just like, it looks like a heartbeat, that heartbeat thing. Can't read a signature, doesn't matter what they do. If you can't read it, let them go. If you can read it, it has to be exactly the way it is under that line. But it only matters on the properties. Okay, it does not matter on their will, on anything else. It matters on that. Okay. And you don't have to make someone sign their name legibly. That's not a thing. Okay. Sometimes there will be an affidavit in the trust package. The affidavit says things like, you know, I'm not doing this to hide money and I don't owe child support and this isn't going to make me broke, insolvent. So that they need to stop and read it, and they can't sign. I have them wait, don't sign it. I need to swear you in. The affidavit, you have to swear them in. So let's do the oath. Okay. By law, your hand has to be up. Okay. By law, their hand has to be up unless they have a physical disability that does not allow it. By law, the oath must be verbal. By law, the response must be verbal. So the oath is a question. Do you solemnly swear? That's also by law. It needs to start with, do you solemnly swear or affirm that the contents of this document are true and you're signing of your own free will? And they say yes, and you go on. But before I give the oath, I say, is everything true? And they say yes. And I say, that's your answer. Because people don't know what to say. They'll be like, I do, or they'll try to repeat you. It's very weird sometimes. It's different for people. It's a little bit awkward for people, but it is something that you have taken an oath for. So you need to learn the oath. Okay. And then the other thing that might be in a package, and it's just, it doesn't get notarized, but they would like you to have it signed. If they own a business and they're putting the business into the trust. So that might be there. And everybody who's listed on there needs to sign it. Okay. So in this case, the wife owns a business, but she's putting it into the trust for the both of them. And now technically, I guess both of them own it. I don't know. Doesn't matter to me because I'm just gathering signatures. And then that's it. So then what I say is congratulations, you now have a trust. And I put things away and I say, thank you very much. And I close everything up and I bring it over and I say, as I'm packing up, I let them know that they can keep the pens. And then I tell them that if they have time and they would like to leave a review for the law firm, they would appreciate that. And nobody ever says no. They probably don't do it, but they don't say no. I don't promote my own business unless the law firm has told me I can. So if they say, do you work for the law firm? I say, no, I have my own business and I do work for the law firm. I don't work for them, but I do work for them. And sometimes they ask for my card, and I've already had a conversation with clients or with the attorneys to say, can I leave my card? And most of the time they say yes. And the reason they say yes is because they don't want to get a phone call from a client asking, or can you send that notary back? This just cuts out the middleman. So when you get any type of estate plan, that's what's involved. Okay, watch my other video to see how to get lawyers to change the way they do things, to want to use mobile notaries. It's kind of saturated, but it's not going away. So do what you need to do and get yourself out there, make yourself available to attorneys, get some confidence, gain some confidence, come with me and I'll show you how it's done. It's really super easy. We're in and out most times in 20 minutes, and that's with pleasantries. Sometimes it takes longer because they get distracted, but we just stay in control. And as long as you stay in control of your appointments, you'll be in and out in 20 minutes. Most appointments don't take very long. Every once in a while, we have one that takes longer. That's okay. But that's why we give an hour for each one. If you guys have any questions, reach out to me. I'm always here to help. I'm Leslie Hocker with the Michigan Notary Association. Thank you.